founder and president of Ellis & Company, LLC, is going to introduce our speaker. So you can just pull it out and I'll turn it off.
Okay, because it's okay. Hi there. My name is Peggy Ellis, and I am not an attorney. I've had the privilege of knowing Bob Levy since 1997. Don't do the math. And after selling his very successful investment firm, Bob joined the Cato Institute, where I had the privilege of being government affairs director, which was a very exciting time after Republicans took control of Congress for the first time in 40 years. But Bob then, and this is before he rose to prominence, and he launched what is now the Robert A. Levy Center for Constitutional Studies at Cato and served as their chairman for about 17 years. And Bob is best known, and he rose to even higher levels of prominence when he argued and won before the Supreme Court what is referred to as the DC handgun case. And I can tell you, ladies and gentlemen, that you're in for a treat. Bob Levy.
Can you hear this okay?
Yes. Oh, I didn't take mine.
Yeah, good. Thanks to Peggy. Great to be with you. As you heard, I chaired the board at the Cato Institute, which is a libertarian think tank in Washington, D.C. Actually, I grew up in the D.C. area. Now, my wife and I live in a retirement community here in Naples, where the average age is deceased. So, as you might imagine, health and welfare is the number one priority there. During COVID, for example, everybody had to follow CDC guidelines and wear these N95 masks. Of course, the problem when you live in a retirement community is that anytime someone shouts out N95, one of the residents thinks he has bingo. We had another resident who was about 15 minutes late when we were supposed to meet for breakfast. So we went to check and we found him coming down the stairs to meet us. He had sort of had a death grip on the handrail. He was having trouble getting his legs to function. So we helped him down and he joined us in the restaurant. But when we tried to return after breakfast, he couldn't climb even the first stair. His legs were like noodles, flopping from step to step. So we called an ambulance, and then a little later we checked back with the hospital to see how he was doing. And the nurse said, oh, he's doing fine. Apparently, he had jammed both of his legs down one side of his boxer shorts. So, that's how life is for us octogenarians. This morning, however, the folks whose work we're going to discuss, they are not octogenarians. They're Supreme Court justices, and their ages range from 53, that's Amy Coney Barrett, to 76, Clarence Thomas. Before we get started, though, just a quick word about the Cato Institute and about libertarianism. When I say libertarian, I'm not referring to the political party, but to libertarianism as a political philosophy devoted to private property, free markets, individual liberty, and strictly limited government. At the Cato Institute, we don't endorse candidates or parties. Actually, we're critical of both Democrats and Republicans, but we do have a consistent, I'd call it minimalist view about the proper role of government. Conservatives agree with us on a lot of issues like lower taxes, less spending, and fewer regulations. Liberals do agree with us on other issues like marriage equality, criminal justice reform, and civil liberties. So does that mean that libertarians are philosophically inconsistent? No, in fact, it's conservatives and liberals who I think may be somewhat inconsistent. Conservatives tend to want less government control of the economy, but more government in the social sphere, and liberals are just the opposite. They want more government control of the economy and less government in the social area. Libertarians want small government across the board, a government that stays out of our wallets and out of our bedrooms and out of foreign entanglements, unless our vital interests are at stake. So with that brief background, let's talk about the Supreme Court, specifically how the court is remaking America, and even more specifically, I'm going to cover 10 of the most important, in my view, 10 of the most important cases over the past 5 years. That's 2020 through 2024. And they include issues like gay rights, vaccine mandates, gun control, abortion, election integrity, student loans, affirmative action, administrative regulation, and of course, presidential immunity. And by the way, the court gets about 8,000 petitions for review each year. Out of those, 60 to 70 cases are decided annually. So the 10 cases that I'm going to talk about are the pick of the litter. And as you might expect from a conservative court, most of these, but not all of them, moved the country to the right. The liberals did chalk up a couple of victories on gay rights, on election integrity, and a partial win on the vaccines. So let's set the stage with a look at the court's makeup. When the 2020 term started, there were 5 conservatives on the court. By seniority, they were Thomas, who's now served 33 years, Chief Justice Roberts, 19 years, Alito, 19, Gorsuch, 7 years, and Kavanaugh, 6 years. On the liberal side were Sotomayor, who's now been there for 15 years, and Kagan, 14 years, plus in 2020, former justices Ginsburg and Breyer. So in September of 2020, Ginsburg died, age 87, after 27 years on the court. For a few of those 27 years, she resisted a lot of pressure to step down and let her successor be appointed by Obama. But instead, she stayed, and as a result, her replacement was Amy Barrett, a conservative, who was pretty hastily confirmed at the end of the Trump presidency. Barrett's appointment to the court increased the conservative majority to 6-3, and that mix stayed the same when Breyer retired in June of 2022, and Biden then appointed Ketanji Jackson, who's the court's newest liberal, but she replaced a liberal, Stephen Breyer, and that's where we stand today. In the most recent term, that is the one ended last early July 2024, about 20% of the cases were decided 6-3 along liberal conservative lines. That's about twice the long-term average, and I think the higher percentage was likely due to the politically charged nature of the latest cases. As usual, Chief Justice Roberts was in the majority more than any other justice. He is trying hard to bridge the liberal-conservative gap. Nearly half the decisions were unanimous, and that's roughly equal to what it has been in prior years. So that brings us to the meat of the matter, the cases with the biggest impact on the country. Obviously, I'm not going to be able to explore all the details, but I'll try to hit the major themes. I don't pretend to be a neutral observer, but my intent here is to summarize and not to advocate. My apologies if there are a few irresistible exceptions. So we begin with the 2020 term, and our first case was an unexpected win for gay rights advocates from a conservative court. The case was Bostock versus Clayton County, Georgia. It was about Title VII of the 1964 Civil Rights Act, which bans discrimination in employment based on race, color, religion, sex, or national origin. But it was thought not based on sexual orientation or on sexual identity. In fact, Congress had tried 3 times to add sexual orientation to the act, each of those 3 times without success. no one really doubted that the legislators back in 1964, when the Civil Rights Act was passed, they were not thinking about lesbian, bisexual, gay, and transgender workers. Nonetheless, Justice Gorsuch, a conservative, joined by Roberts, a conservative, and the four liberals held that the plain language of the statute prohibited discrimination against LGBT employees, despite what was the legislative intent, what was the history of the matter at the time, and the prior practice. So how did Gorsuch reach that conclusion? Well, he defined sex as the biological gender of a person at birth. He conceded that Clayton County's discrimination against homosexuals and transgenders did not depend on their sex because the county treated gay men the same as it treated gay women. Still, said Gorsuch, if a man and a woman both showed up with a spouse named, say, Karen, only the woman would be fired and not the man. And that's illegal, according to Gorsuch, because Title VII protects individuals and not just groups. Justice Alito, for the dissenters, he would have ruled based on the ordinary meaning of the word sex, and he rejected the Karen example, noting that Karen's wife, another female, would have been fired based on her sexual orientation, not based on her gender. Employers who discriminate on that ground, that is sexual orientation, they might be called homophobic. They might be called transphobic. They wouldn't be called sexist. Ultimately, the Bostock case revealed an unusual split among the so-called originalist justices who are usually aligned in interpreting the text of the law. Now, my own sense of the matter is that the dissenters had the better of the argument on textual grounds. But as a result of the majority decision in this case, Title VII does now prohibit employment discrimination against LGBT workers nationwide. And remember, it is not whether that's an outcome that you like, but whether the court correctly interpreted a law that Congress had enacted. So the next up is a pair of 2022 decisions on vaccine mandates. One of the cases, Biden versus Missouri, was another win for the administration. It was an unsigned 5-4 opinion by the three liberals, plus Roberts, a conservative, and Kavanaugh, a conservative. The court held that the Department of Health and Human Services, HHS, could require healthcare workers at facilities that participate in the Medicare and Medicaid programs to be fully vaccinated against COVID. Now, what the court reasoned was that a core function of HHS is to protect the health and safety of workers who do come in contact with patients. Maybe so, said the dissenters. That's Thomas, Alito, Gorsuch, and Barrett. But there's no provision in the law, they said, for HHS to force vaccines on 17 million workers. Congress might have been able to do that, but Congress did not do that. Health and Human Services did it. Now, the court reached a different result when the taxpayers weren't footing the bill. That is, when private medical facilities were involved. In National Federation of Independent Businesses versus Department of Labor, the 6 conservatives held that the Occupational Safety and Health Administration, OSHA, could not order all private sector companies with more than 99 employees to get vaccinated. The unsigned opinion, again unsigned, stated that OSHA's role is to safeguard against hazards created by the workplace, not to shield employees from a global public health epidemic. That's up to state governments, it's up to Congress, it is not up to OSHA. Statutory authority, said the court, has to be clear and explicit when addressing a massive regulatory program that, in this instance, covered 80 million workers. And that seems to me to be the right outcome. The next major 2022 case was about gun control. A 1913 law required a special need in order to get a concealed permit in New York. The case was New York State Rifle and Pistol Association versus Bruin. The plaintiffs were granted permits for target practice, for hunting, but not for self-defense. Not so fast, said Justice Thomas in a 6-3 opinion. Again, it was split along ideological lines. He held that Americans have a right to carry a handgun outside the home for self-defense without proving they faced a threat to their safety. It's still okay for the states to deny permits based on objective criteria, such as age, lack of training, mental impairment, but laws giving excessive discretion to bureaucrats are likely unconstitutional. And that'll affect not just New York, but also regulations in DC, California, New Jersey, Maryland, Hawaii, Massachusetts, and elsewhere. Prior to Thomas's opinion in this case, the court had typically weighed public safety on the one hand versus Second Amendment rights when considering gun restrictions. But now, after this case, the Bruin case, the only guidepost is whether a proposed gun control regulation is consistent with the text, history, and tradition of gun laws. So Bruin is a really big change, both because it's the first case to extend the right to carry beyond the home, and because the court overhauled its Second Amendment framework by insisting that there be a comparable prior regulation. Bad idea from my perspective. Justices are not historians. There is too much wiggle room trying to match past and current laws. There is no necessary overlap between laws that are already on the books and laws that are constitutional. Some of the old regulations were unconstitutional, but they were never challenged. Some of the regulations were not enacted because they weren't needed in the 1790s, or they might have been rejected for policy reasons or for political reasons, even though they would have passed constitutional muster. So maybe it's useful to look at history and tradition if the constitutional text is unclear or if the text leads to absurd consequences. But otherwise, the selective use of history can be an excuse for judges to reach their preferred policy outcomes. Next, in 2022, the blockbuster decision, Dobbs versus Jackson Women's Health Organization, which overturned a half-century of abortion jurisprudence. Justice Alito, another 6-3 conservative liberal split, upheld a Mississippi law that banned almost all abortions after 15 weeks of pregnancy. Most importantly, he explicitly overturned Roe v. Wade and Planned Parenthood versus Casey. He declared that individual states, not the feds, could decide their own rules. And that principle may be tested soon if a future Congress tries to legislate either a national right to abortion or a national ban on abortion. Alito pointed out that the U.S. Constitution does not mention abortion, nor is abortion deeply rooted in the nation's history and tradition. In fact, until late in the 20th century, there was no legal or popular support for a constitutional right to abortion. And Alito also stated that abortion destroys a potential life, which distinguishes it from other cultural war issues, such as, for example, same-sex marriage, that does not involve third parties. Accordingly, said Alito, nothing in his opinion should be understood to cast doubt on precedents that do not concern abortion. So that wasn't much consolation for the liberal justices who wrote in dissent that women are autonomous with full equality, which means they must enjoy substantial choice over their personal and consequential life decisions. Interestingly, Chief Justice Roberts wrote a separate concurrence that would have upheld the Mississippi statute, but without ditching Roe v. Wade. Roberts would have retained the Roe framework that a law must not impose an undue burden on the mother. He claimed that Mississippi's law met that standard by allowing 15 weeks, that is more than 3 months, to obtain an abortion. That's not, he argued, an undue burden. And he pointed to data showing that 95% of all abortions occur before 15 weeks. Now, by contrast, Roberts conceded that Casey's viability standard, estimated at 23 to 24 weeks, not only was too long, but also depended on factors such as medical technology that were not related to the legal rights of either the fetus or the mother. No other justice, however, joined with Roberts in his attempt at compromise. For what it's worth, by the way, from my own perspective, grounded in my Jewish heritage, is that the fetus isn't fully viable until it graduates from medical school. So turning to 2023, we revisit the gay rights issue, this time in the context of its interaction with free speech. And this case was 303 Creative LLC versus Elenis. The question was whether a Colorado website designer could refuse to create a site for a same-sex wedding. So here's a quick recap. The First Amendment protects speakers from having to say things that offend them. In this case, 303 Creative did not refuse to serve gay people. Lori Smith, the owner, said she would design them a website for just about any occasion, but not for their wedding. Nor would she design a same-sex wedding website sought by heterosexual friends as a gift to the gay couple. And she wouldn't design websites containing other messages that offended her, like, for example, a site that promoted abortion or gambling. So to Smith, it was the message that mattered and not the identity of the customer. Justice Gorsuch wrote the opinion for a 6-3 court, again divided ideologically. He held that the First Amendment prohibits Colorado from forcing a website designer to create expressive designs containing messages with which she might disagree. So, Lori Smith can speak her mind, no matter if Colorado considers her views well-intentioned or deeply misguided. Sotomayor, Kagan, and Jackson, the 3 liberals dissented. They claimed that Colorado's law targeted conduct, not speech, and protected conduct does not include the right to discriminate. Sotomayor wrote, quote, "Our Constitution contains no right to refuse service to a disfavored group." But that statement, I believe, misreads the case. As I noted, Lori Smith did not refuse to serve gays. She simply refused to promote gay marriage. Moreover, Sotomayor's position could be cited to buttress the notion, for example, that Jewish accountants have to keep books for businesses run by Hamas, and black caterers have to provide food for Klan weddings. That's not what I'd call freedom of association. Okay, most of the cases I'll be discussing today favor the conservative viewpoint from a conservative court. Some folks on the left charge that today's conservative court is also a MAGA court that supports Donald Trump's political agenda. After all, Trump did appoint 3 justices, enlarging the court's majority. But now I'm going to discuss a case, 2023, that decidedly points in the other direction. It rejects what's called the independent state legislature doctrine. And that's the idea that state legislatures can pass election-related laws without those laws being reviewed by state courts. The case was Moore versus Harbor, a big defeat for Trump. North Carolina Republicans had sued to reinstate a map that was struck down by the North Carolina Supreme Court on the grounds of partisan gerrymandering. Now, the issue before the U.S. Supreme Court was not whether the redrawn districts were permissible. This was not a redistricting case, but rather whether state courts have any role in monitoring election laws that are passed by state legislatures. The Elections Clause in the U.S. Constitution says that the time, place, and manner of congressional elections shall be prescribed by the state legislature. It doesn't say that state courts can review those legislative acts. So, should the word legislature in the Constitution be interpreted literally to exclude state courts, or does the term refer more broadly to a lawmaking system that involves all three branches of government? The implications are far-reaching. Under the independent state legislature doctrine, state courts would not be able to second-guess Trump's attempts to have state legislatures overturn the will of the voters. Chief Justice Roberts, joined by Kavanaugh, Barrett, and the three liberals, affirmed that state legislatures prescribe rules for federal election, but subject to ordinary review by state courts, and thus the Supremes rejected the independent state legislature doctrine, and that holding eviscerated Trump's claim that state legislatures could, without state judicial review, have overturned the 2020 election. The next 2023 case is Biden versus Nebraska, which challenged a presidential executive order partially canceling repayment on 92% of all student loans, excluding, by the way, only the top 5% of households by income. So how much would the canceled loans have cost? Estimates varied from $300 to $600 billion. Who would have been helped? A lot of folks, including some who earned quite a bit of money. Who would have been harmed? Mostly non-college graduates. That's 2/3 of all the taxpayers who earn about $1.25 million less on average over their lifetimes than folks who earn a bachelor's degree. So the legal issue was whether Biden was authorized to bypass Congress with his executive order. And he claimed authority under what was called the HEROES Act, which says that the Department of Education can waive or modify student loan provisions in connection with a national emergency for borrowers who are affected by the emergency. So that language triggered three challenges. First, did the term waive or modify allow cancellation? Second, did COVID still qualify as a national emergency, particularly since Biden himself has said it's over? And third, was it conceivable that 90% of student borrowers were actually affected by COVID? Chief Justice Roberts wrote the opinion for the conservative bloc. He held that the word modify meant to change moderately or in minor fashion, but not to cancel. And results, the loans could not be canceled by executive order. As you've probably heard, the court's opinion did not deter Biden. He invoked different statutes to push modified versions of his loan forgiveness program. But in August of 2024, the Supremes also put one of his revised programs on hold. So stay tuned. Either Trump will cancel the programs or there will be more lawsuits filed. And next, the biggest case of the 2023 term, and that involved affirmative action. There were actually two cases, Students for Fair Admissions versus Harvard, consolidated with a similar lawsuit involving the University of North Carolina. The issue was whether to overrule a case called Grutter versus Bollinger. That was a 2003 decision that allowed the University of Michigan Law School to use race as an admissions criterion in order to achieve a diverse student body. The plaintiffs at Harvard and UNC alleged that the affirmative action programs at those two colleges discriminated against Asians in violation of the Constitution's Equal Protection Clause and Title VI of the Civil Rights Act, which applies to private colleges like Harvard that receive a lot of federal funds. Chief Justice Roberts wrote for the conservatives, essentially overruling the Michigan case, but without formally saying that he was doing so. First, said Roberts, the college's interest in racial diversity wasn't adequately explained or measurable. Second, the racial classes were unclear. Asian was too broad, Hispanic was undefined, Middle Eastern was omitted altogether. Third, because there were limited admission slots, one person's gain would be another person's loss, so that race was used both positively and negatively to the disadvantage of Asians. Fourth, by assuming that students of a particular race are all alike, the programs were guilty of stereotyping. And fifth, the programs lacked any meaningful termination criteria. Roberts then concluded by offering an olive branch. He volunteered that nothing prohibits universities from considering the effect of race, so long as it's tied to character or unique ability that the applicant can bring to the university, things like skills developed, challenges met, or lessons learned, but not merely the color of the student's skin. And I would add this comment: if diversity is such a compelling interest, why not diversity by measures other than race? For example, religion, nationality, socioeconomic status, geography, and perhaps most important, diversity of viewpoint. According to a recent survey, Harvard's class graduating this year is 72% liberal and less than 9% conservative. And the faculty, of course, is like-minded. So maybe what's needed is affirmative action for conservatives. So we end with two cases from last year, 2024. Two very big cases. First, Loper Bright Enterprises versus Raimondo, which overturned what's called the Chevron doctrine. It sounds arcane, but it's really critically important. Part one of the doctrine goes like this: if Congress passes a law that directly addresses an issue and the intent of Congress is clear, then the statute controls. But part two, if the statute is silent or if it's ambiguous, the courts under the Chevron doctrine will defer to any reasonable reading by the agency. The Chevron doctrine has been targeted by libertarians and conservatives since its adoption 41 years ago. And they argue that it lets Congress off the hook and gives far too much discretion to unelected officials. Over the years, Chevron has been the fuel that's driving the administrative state, empowering these regulatory agencies under both Democrats and Republicans. So now Chevron is gone. And Chief Justice Roberts, joined by his conservative allies, said it's not enough for agency interpretations to be merely reasonable. They have to be the best. And the courts, not the agencies, are going to make that judgment. And Roberts added that yielding to the agencies was especially problematic when it was the agency's own power that was frequently at issue. And moreover, Chevron deference produced flip-flop regulations each time a new administration took over. So if Congress still needs technical help, it can certainly consult with agency experts or turn to policy professionals, trade groups, businesses, think tanks, academics. But the courts, not the agencies, are going to decide these legal issues. The Loper decision will no doubt lead to lots of new challenges to regulations by federal agencies like EPA, HHS, the SEC, and by extension to presidents who misuse executive orders. Bottom line, the Loper case is a big deal, and maybe at last Congress will legislate and not pass the buck. And finally, we have Trump versus United States concerning his claim of immunity from prosecution related to January the 6th. Chief Justice Roberts, again for the 6 conservatives, held that the president is absolutely immune for criminal prosecution for exercising his core constitutional powers, like the pardon power, his commander-in-chief power. And the president is presumptively immune for acts that fall within the outer perimeter of his official responsibilities. Now, by presumptive immunity, the court means that the president would indeed be immune unless the government could show that criminalizing the president's conduct would not intrude on the functions of the executive branch. A pretty high bar. Roberts did stress that there is no immunity for unofficial acts, but that still leaves prosecutors with a big burden. For example, is it official or unofficial to assassinate a foreign enemy? It'll be very hard to draw those kinds of lines. Practically speaking, the court reduced Trump's exposure for January 6th, delayed the start of his trial, which, as you know, has now been scrapped. Even if the trial had moved forward, lower courts would have been faced with deciding which counts covered purely unofficial acts. Did Trump's January 6th conduct and his conversations with state electors qualify as official or unofficial? And that probably depended on whether Trump was acting as a candidate or as a president. And because the case was dropped, we don't know the answer. But all in all, it's fair to say the court has very likely, and I frankly think mistakenly, expanded executive power. The doctrine of presidential immunity is nowhere to be found in the text, the history, or the tradition of the Constitution. And separation of powers, which is a centerpiece of the Constitution, is about checks and balances, not unbridled executive action. Some form of presidential immunity may arguably be a very good idea, but we shouldn't confuse good ideas with what it is that the Constitution requires. Okay, that's my story. I'm sticking to it. The cases I've discussed involve, some of the major issues that the Supreme Court has tackled over the past 5 years. Obviously, the country faces many other problems, some even more serious than the ones I've discussed today. Just to name one, a respected political pundit has written that 2024 is the year that humanity finally realized it faces an existential threat, a threat that will wreak havoc on our fragile environment if we fail to stop it, and it may already be too late. He was referring, of course, to pickleball. Nobody knows where it started, and some scientists believe it escaped from a laboratory in China. Whatever its origin, pickleball courts now cover 43% of the continental U.S. So with that warning in mind, we have time, I think, for your questions. Feel free to ask about the cases I've covered, any upcoming cases for 2025, or any other legal or constitutional issues that are interesting. Yes?
The case that was decided by the Supreme Court yesterday, where Amy Coney Barrett, I didn't read it, so I don't know what she was hanging her hat on in terms of siding with the majority and saying that he could be sentenced. Do you know?
Yes, that the imposition on the executive branch would not be consequential, since the judge had already announced that he would not impose any serious jail time at all. So basically, today there was the sentencing. Trump was found guilty on all 34 counts, and Merchant, the judge, sentenced him, even though Trump had attempted to delay sentencing, but that attempted delay was, as you know, turned down by the Supreme Court. And the reason was that Trump got no jail time, no fine, and no probation. Now, my own comments on that case is that it should never have been brought. I'm not suggesting that he wasn't guilty. I'm simply suggesting that it was at most a misdemeanor, and the elevation of this case into some felony charge, 34 counts, including felonies and misdemeanors, was, I think, politically motivated. The theory of the case was that beginning in 2015, Trump had concocted what's called a catch and kill scheme with David Pecker from the National Enquirer to suppress bad publicity. Then Trump falsified business records, which is a misdemeanor, with the intent to conceal or commit another crime. And that other crime was a felony state election law that bars conspiring to promote a candidate by unlawful means. So this is a contrived set of charges designed to accomplish a political goal. Again, not that he wasn't guilty of doing what he did, but what he did was at most a misdemeanor charge for falsifying state documents. Now this is likely to be challenged, and I think he has a realistic chance on appeal, although it could take years to come back and be resolved. Yes.
Do you listen to Mark again? Because on Sunday evening on his show on Fox, and then again this morning they had him talk as his trial was unfolding. And he said that it should have been, the Supreme Court didn't do what they needed to do. They should have never allowed it to go any further. Because, and he said Sunday, because this can set a precedent now for other little town DAs and their judges to go after a president. Do you agree with that?
Well, I certainly agree that this could set a precedent, but the court is very unlikely to say to a state that they cannot bring a lawsuit, even though the lawsuit was goosed up to be something more than would have been prosecuted against anyone other than President Trump. So I don't believe there's a technical legal error in the state prosecuting this case. I do think it was politically motivated. I do think it was contrived in order to get up to a felony charge. But I doubt that a federal court would step in and tell a state court that they couldn't prosecute the case. Other questions? Yes.
Will Trump be able to vote as a felon that is on the state?
Most states, well, actually, I don't know whether it's most or some, but some states have restored voting rights to felons. I don't know. I think Florida has, as long as you have paid whatever the court costs were in the context of completing the litigation that developed in your case. So if you've paid all the court costs, I believe in Florida, although don't take my word for this, I believe in Florida that felons have restored rights to vote. It may be that it's only for certain felonies that it's been restored, like nonviolent felonies. But if that's the case, this would certainly qualify as a nonviolent felony. I don't recall Trump having carried out violence against the documents that he falsified. Yes.
One quick question. Do you ever see in the future court packing, or is that just a wrap?
Well, Biden made 3 proposals. I see one of them has a good chance of happening, one no chance at all, and the third maybe. The one that has a good chance is 18-year term limits. And the reason it has a good chance, it's a good idea with some bipartisan support, and it would accomplish a number of things. One is that it would prevent justices from gaining too much power by being on the bench for so long. Secondly, it would get rid of justices who are no longer performing effectively. And third, and most important, it would depoliticize the confirmation process. So if you had 18-year terms, terms would expire every 2 years. And that would give each president an opportunity to appoint 2 justices to the Supreme Court. That, I think, would go a long way toward depoliticizing what has become a dysfunctional political process. The second proposal is very unlikely to happen, and that is expanding the number of justices. By the way, there's nothing in the Constitution that specifies how large the Supreme Court has to be. In fact, it's changed size a number of times from 5 to 10 justices, although the number 9 has been around since the mid-1800s. So Congress could change the size of the court by statute without a constitutional amendment. To pass a filibuster, it would take 60 votes in the Senate. But to do that under current Senate rules, you'd have to either waive the filibuster, because you're not going to get 60 votes. And the party with the majority could, if it chose, eliminate the filibuster rule. When FDR tried to do that, he found out how unpopular it was. And just as an aside, a quick aside, he decided to expand the number of justices to 15 when the Supreme Court was voting consistently against his New Deal programs. And then one of the justices, Owen Roberts, suddenly started switching his votes, supporting the New Deal. And it became known as the switch in time that saved 9. And 9 being the members of the court. But like then, now, this is a very unpopular mechanism, and if it's passed, what would happen is just a series of retaliations every time the Senate majority changes hands, further politicizing the court. And then very quickly, the ethics issue was the third thing that Biden proposed. Again, I think Thomas followed and Alito followed the letter of the law, but they should have done more, even though they complied with the letter of the law. The law has now been changed. They have a more rigorous reporting requirement. Thomas says he's following it. I think the court, just to enhance their own respectability and the way in which they are perceived by the nation, should voluntarily adopt a much more rigorous and stringent code of ethics. Thank you all very much.
Thank you so much. That was so interesting.
You bet.